course, we still hold the trump card.
Which is?
Well, we make the rules.
As many of you know, there are certain evidence that I would have liked to have seen led in this trial, but for a variety of reasons we were not able to do so. At some point, that information, that facts and that evidence will see the light of day.
A few weeks ago, I was passed some papers from an anonymous whistleblower. The information in those papers consisted of a download of text messages from the telephone of Sue Riddick, the Chief Operating Officer of the SNP. Now, the download that I'm talking about, Sue Riddick's telephone download, is held by the Scottish Police. So the accuracy of this account can be checked if they need to. Now, Alex Salmond has asserted that there has been, and I quote, a malicious and concerted attempt to remove me from public life in Scotland by a range of individuals within the Scottish Government and the SNP, who set out to damage his reputation, even to the extent of having him imprisoned. These are incredibly grave charges. The whistleblower clearly agrees with those charges. He or she starts their communication with the assertion that the evidence provided, and I quote, point to collusion, perjury, up to criminal conspiracy. Since I received the data, it looks as though the committee has received at least some of it themselves, and some has also been put in the public domain by the Honourable Member for East Lothian, a previous Justice Secretary in the Scottish Government. It was described anonymously by one of the committee members as, quotes, just private conversations that we had no business intruding on. Well, I'll let the House be the judge of that. No single sequence of text is going to provide conclusive proof of what the whistleblower described as a criminal conspiracy. But it does show a very strong prima facie case which demands further serious investigation, by which I mean at very least a thorough review of all the emails and other electronic records for the relevant personnel at all relevant times. Now, for example, these texts show that there was a concerted effort by senior members of the SNP to encourage complaints. The messages suggest that SNP Chief Executive Peter Morrell coordinated Ruddick and Ian McCann, the SNP's compliance officer, in the handling of specific complainants. On the 28th of September, a month after the police had started their investigation of the criminal case, McCann expressed great disappointment to Ruddick that someone who had promised to deliver 5 complainants to him by the end of that week had come up empty or overreached, as he put it. This means that evidence relevant to the Hollywood inquiry can be freely discussed here, today, using parliamentary privilege. But if an MSP in Holyrood were to do the same, they'd likely find themselves facing down prosecution. Indeed, the Crown Office has been making such threats to Mr. Salmond's lawyers, to various journalists, and even the Holyrood inquiry himself. They made clear that they would deem disclosure of evidence to a committee of elected representatives to be a criminal offence. We have known for centuries that separation of powers is fundamental to a functioning democracy. Yet in Scotland, the Lord Advocate both leads the prosecution service and serves in the Scottish Cabinet. This leaves him conflicted and compromised, with his department's independence undermined.
In August 2016, Mr Clark and Mr Whitehouse initiated civil actions against me. I had been appointed on 2nd June 2016, seeking damages on the grounds of malicious prosecution and breaches of Articles 5 and 8 of the European Convention on Human Rights. They also advanced claims against the Chief Constable of Police Scotland. I advanced a defence relying on established legal authority that the Lord Advocate is immune from common law liability. That defence was upheld at first instance, but in October 2019, the Inner House of the Court of Session overturned the previous legal authority and allowed the claims to proceed. On 20th August 2020, I admitted liability to Mr Clark and Mr Whitehouse. Those admissions followed the conclusion of a very substantial and lengthy investigation undertaken by the legal team, including external counsel, instructed on my behalf. As a result of that investigation, I concluded that the decisions to place Mr Clark and Mr Whitehouse on petition in September 2015 and to indict them were indefensible in law. I concluded that those decisions proceeded without probable cause, i.e. without a proper evidential basis, in circumstances which met the legal test for malicious prosecution.
Of course, we still hold the trump card.
Which is?
Well, we make the rules.